and it says, what's the difference between a will and a revocable trust? I need to set something up for my mom and want whatever is best for her. What do you think?
Sure, absolutely. First of all, thank you, listener, for the email, and we are happy to answer that for you. A will is different than a trust. A will is very important and it can direct who's in charge and it can direct who you want things to go to when you pass away. However, a will does not avoid probate. So you would have to make sure that you do and take the additional steps to avoid probate. We, though, are about keeping it simple. Most of the time, a last will and testament is perfectly fine for most people, including possibly mom. She may be asking about this for elderly mom. Most of the time, with elderly parents, whether it's the elderly parent or it's their adult children that want to help them to make sure that they have documents set up in place, a will be perfect, saying that the will, everything goes equally to the children, the adult children, and then from there they make sure that their financial accounts have beneficiaries placed for all their adult children, and then if mom has a home, we make sure that we do the deed to avoid probate on her home. Once again, matching the will and saying everything goes to equally to her adult children. Of course, along with the will, we are also doing the related documents, which are those power of attorney documents that mom also needs. But to answer the caller's question, so that is a will. What is the revocable trust? A revocable trust is a different tool. Once again, will also say who's in charge, and it will also say that things, for example, go equally to my 3 children. The difference being that the revocable trust is a tool to avoid probate where you can name that trust as beneficiary for those bank accounts, and you can name that trust as beneficiary on the deed to avoid probate. So it is a tool for people. Again, we are about keeping it simple. So the significant difference for you listeners out there is that a revocable living trust is appropriate for, typically, we're going to give you the general categories of people that may need that. One, if you are leaving something to minor children, whether it is you as the parent to minor children or you as the grandparent. If you are a grandparent and you want to leave something directly to minor children, yes, you must do that with a trust. And of course, if you have minor children as a parent, you must do that with a trust. The other typical reasons would be that for you have adult children and you have one or more that you do not want them to get their share outright. That is another reason to have a revocable trust. Or you may have adult children with addiction issues. Some of those are the main reasons. What is not, it does not have anything to do with how much wealth you're leaving. It's about why in your family situation. We're happy to guide you. We are happy to do a free consultation for you. Hopefully that gives a tiny overview to the radio listener about the difference between a last will and testament here in Florida and a revocable living trust.
So the email was, what's best for my mom, a will or a living trust? A better way to phrase that question is, what's the best way for my mom to avoid probate?
Exactly.
People want to avoid probate because it's expensive and takes a long time, and we might use a will for that. We might use a living trust for that, but we're here at the Olsen Law Group. We're all about helping people to avoid probate. Hey, folks, my name is Tom Olsen. The name of the show is Olsen on Law. We're going